legal innovators and tech enthusiasts. Ibrahim here. Today we are diving into something that's transforming the legal industry faster than anyone predicted 5 years ago. The intersection of artificial intelligence and legal contracting. Now, let me be crystal clear from the start. I'm not a lawyer, never passed the bar exam, never argued a case in court. But after 3 decades in enterprise technology and working with over 40 law firms on their digital transformation journeys, I've seen firsthand how artificial intelligence is revolutionizing the way contracts are created, analyzed, and managed. Last month, she told me something that stuck with me. Ibrahim, she said, our junior associates used to spend 70% of their time on contract review. Now they're solving complex legal problems while our artificial intelligence systems handle the routine work. That's not the future, that's happening right now. So here's what actually works when you combine structured contract principles with artificial intelligence automation. The reality nobody talks about? Most contracts are chaos. I've reviewed thousands of them while implementing document management systems, and the inconsistency is staggering. One attorney uses shall, while another prefers will. The payment terms appear in Section 3 of one contract and Section 7 of another. This randomness kills efficiency. But when you implement structured contracts, and I mean truly structured with consistent components and predictable patterns, something magical happens. The law firm I mentioned earlier, they reduced their contract drafting time by 40%. Not through some expensive new software initially, but simply by standardizing their contract anatomy. Here's the game changer though. Once contracts follow a consistent structure, artificial intelligence can actually understand them. Natural language processing, that's NLP for those keeping track, can extract key terms with 95% accuracy. Machine learning models identify non-standard clauses instantly. What used to take a junior associate 3 hours now takes 3 minutes. I witnessed this transformation at a Boston firm specializing in mergers and acquisitions. They were drowning in due diligence reviews, analyzing hundreds of contracts for each deal. After implementing structured contract templates and training their artificial intelligence systems, they tripled their deal capacity without adding a single lawyer. The partners couldn't believe it until they saw their billable hours actually increase because they were handling more strategic work. Now look, every contract, whether it's a simple non-disclosure agreement or a complex merger document, follows the same fundamental architecture. 14 components. That's it. This isn't some academic theory. I learned this from Sarah Chen, a contracts attorney who built one of the most successful legal automation practices in Silicon Valley. She showed me how every single contract, regardless of complexity, contains these same building blocks. Once you understand this architecture, you can teach artificial intelligence systems to parse any contract with remarkable precision. Think of it like the blueprint for a house. Every house needs a foundation, walls, a roof. The style might change, the size might vary, but those core components remain constant. Contracts work exactly the same way. Let's start with the foundation, the title and preamble. This section seems simple, but it's where many contracts fail before they even begin. The opening identifies your parties with their full legal names and jurisdictions. Sounds basic, right? But I've seen million-dollar deals nearly collapse because someone incorporated as Inc. inconsistently throughout the document. One financial services client discovered they had 17 different variations of their company name across their contract portfolio. 17. The effective date establishes when obligations begin, critical for timeline calculations, critical for compliance tracking, critical for everything that follows. Yet I regularly see contracts where the effective date conflicts with dates mentioned later in the document. Here's where artificial intelligence changes everything. Natural language processing can extract this metadata automatically in seconds, but more importantly, it validates entity names against corporate databases. When we implemented this for a healthcare system in Texas, their artificial intelligence caught over 200 instances where vendor names didn't match their official registrations. Each one was a potential enforcement nightmare waiting to happen. The system also flags inconsistencies, different spellings, missing middle initials and signatory names, jurisdiction mismatches. A human might miss these reviewing 50 contracts a day. The artificial intelligence catches them every single time. That healthcare system reduced their contract review time by 75% just on this section alone. Moving to recitals, the whereas clauses that everyone skips but shouldn't. Recitals provide context. They tell the story of why this contract exists. I remember working with a construction firm that lost a $2 million arbitration because their recitals contradicted their scope of work. The arbitrator ruled that the recitals showed clear intent that differed from the operative clauses. Most lawyers treat recitals as throwaway boilerplate. Smart lawyers and smart artificial intelligence systems treat them as interpretive gold mines. They establish intent, provide background, and most importantly, they help resolve ambiguities when disputes arise. I recently helped a law firm in Miami implement large language models to analyze their recitals. The artificial intelligence doesn't just extract them, it actually understands them. It summarizes lengthy recitals into concise statements. It identifies when recitals conflict with operative terms. One client discovered that 30% of their standard templates had recitals that didn't align with their updated business model from 3 years ago. The really powerful application? The artificial intelligence can rewrite unclear recitals for improved readability. Not replacing the lawyer's judgment, but giving them cleaner starting points. One senior partner told me this feature alone saves her 2 hours per complex agreement. That's 2 more billable hours for strategic work. Now we hit the section that determines whether your contract succeeds or spawns lawsuits. Definitions. Every capitalized term needs explicit meaning. I learned this lesson the hard way while implementing a contract management system for a software company. They had a licensing agreement where user meant different things in different sections. The ambiguity cost them $800,000 in a dispute over seat licenses. Clear definitions prevent disputes before they start. But here's what I've observed. Most lawyers copy and paste definitions from previous contracts without checking if they still apply. One real estate firm I worked with had been using a definition of property from 1998 that didn't account for digital assets or intellectual property rights. Machine learning models excel at definition management. They detect missing defined terms instantly. If you use deliverable with a capital D but never define it, the system flags it. They identify inconsistent usage across clauses. They even suggest standard definitions from template libraries. Here's a real example. A pharmaceutical company was negotiating a research agreement. Their artificial intelligence system flagged that clinical trial was defined differently in the main agreement versus the statement of work. That inconsistency could have invalidated millions in research expenses. The artificial intelligence caught it in seconds during initial review. The numbers speak for themselves. Firms using artificial intelligence for definition checking report 80% fewer definition-related disputes. That's not marginal improvement. That's transformation. The scope of work, where business promises become legal obligations. I've seen more contracts fail here than anywhere else. Vague deliverables, missing acceptance criteria, undefined timelines. A marketing agency I advised lost a major client because their scope said provide social media management without defining posting frequency, platforms, or performance metrics. The best contracts specify exactly what will be provided with measurable acceptance criteria. They set clear milestones and deadlines. They allocate responsibilities to prevent gaps. But achieving this level of detail traditionally required hours of back and forth between lawyers and business teams. Enter artificial intelligence-powered comparative analysis. The system compares scope against prior drafts to track changes. Every revision is analyzed for completeness and clarity. One law firm in Seattle trained their artificial intelligence on 5,000 successful project scopes. Now it flags ambiguous language before it becomes expensive litigation. The artificial intelligence identifies missing acceptance criteria. It highlights scope creep risks. If version 3 of the contract adds responsibilities not present in version 1, the system alerts you immediately. A technology company I work with credits this feature with reducing a scope-related change orders by 45%. Their project managers actually request the artificial intelligence review before signing anything. Money, where contracts get serious and disputes get expensive. Payment terms require precision, not just the amount, but the calculation methodology, invoicing procedures, approval workflows. I consulted for a consulting firm that lost 3 months of cash flow because their payment terms said net 30 days without specifying 30 days from invoice date versus invoice receipt. Pricing structures can be incredibly complex. Fixed fees, hourly rates, success fees, retainers, expense reimbursements. Each needs clear definition and calculation methods. One law firm discovered they had 47 different ways of describing hourly billing across their contracts. 47? Their accounts receivable team was drowning in confusion. This is where artificial intelligence truly shines. Extraction algorithms convert unstructured payment terms into structured data tables automatically. Instead of reading through paragraphs of legal text, you see cleanest spreadsheets with amounts, due dates, and conditions. The artificial intelligence populates financial systems directly. No manual data entry, no transcription errors. It flags non-standard payment terms that deviate from company policy. One client discovered they were offering payment terms 20 days longer than their standard just because nobody was checking consistently. The real power? Total contract value calculation. The artificial intelligence aggregates all payment components, base fees, potential bonuses, renewal values, giving you instant visibility into deal economics. The same consulting firm I mentioned now processes invoices 90% faster with near zero payment disputes. Service level agreements create measurable performance standards, uptime commitments, response times, resolution metrics. But I regularly see SLAs that are essentially unenforceable because they lack measurement criteria. System will maintain high availability means nothing legally. System will maintain 99.9% availability measured in 5-minute increments, excluding scheduled maintenance windows. Now that's enforceable. I worked with a managed services provider whose SLAs were so vague that they'd never successfully claimed a service credit despite multiple outages. Their clients were equally frustrated because they couldn't prove violations either. Semantic analysis changes this game entirely. The artificial intelligence highlights vague metrics instantly. It identifies missing performance standards for critical services. It flags weak remedy provisions that provide no real recourse for failures. Even better, it compares your SLAs against industry benchmarks. When a cloud services provider tried to offer 95% uptime for a mission-critical system, the artificial intelligence flagged that competitors' standard was 99.9%. That insight prevented a deal-killing negotiation point. One technology company improved their SLA enforceability by 70% after implementing artificial intelligence review. They're now collecting service credits that previously went unclaimed, and their vendors are delivering better service because the standards are crystal clear. Data protection, where contracts meet compliance nightmares. Post GDPR, that's General Data Protection Regulation. For those unfamiliar, data provisions can't be afterthoughts. I've seen companies face seven-figure fines because their contracts didn't properly address data processing requirements. One healthcare startup nearly lost their largest client because their data handling clauses didn't meet HIPAA requirements. That's the Health Insurance Portability and Accountability Act, by the way. Confidential information definitions determine what's protected. Too narrow, and your trade secrets leak. Too broad, and the contract becomes unworkable. Data handling obligations need specificity, encryption standards, access controls, breach notification timelines. Compliance engines powered by artificial intelligence are game changers here. They check contracts against GDPR, HIPAA, CCPA, that's the California Consumer Privacy Act, and company-specific policies simultaneously. What would take a privacy lawyer hours takes seconds. The artificial intelligence flags missing data protection clauses. It identifies non-standard handling terms that create compliance risk. Most powerfully, it suggests compliant language pulled from approved templates and updated with latest regulatory requirements. A financial services firm I advise reduced their regulatory risk exposure by 85% using artificial intelligence-powered compliance checking. They went from discovering compliance gaps during audits to preventing them during contract drafting. Their legal team sleeps better, and their compliance officer actually smiled during the last audit, where ownership disputes destroy business relationships. I've witnessed eight-figure lawsuits over unclear IP ownership. A software developer thought they retained rights to code they developed for a client. The client thought work for hire meant they owned everything. Neither contract explicitly addressed derivative works. Both parties lost in legal fees. IP clauses must specify who owns pre-existing intellectual property, new developments, and derivatives. License grants need clear scope, duration, and limitations. Too many contracts just say party A owns the IP without defining what the IP actually includes. Pattern recognition in artificial intelligence systems excels at IP analysis. The technology flags problematic assignments instantly. If your standard policy is to retain ownership of your pre-existing IP, but this contract assigns it away, immediately. The artificial intelligence identifies overly broad license grants that could handicap future business. It detects missing work-for-hire provisions that could create ownership disputes. One software company discovered that 20% of their contractor agreements lacked proper IP assignment language. Each one was a potential lawsuit waiting to happen. By ensuring consistent IP treatment across contract portfolios, artificial intelligence prevents disputes in 95% of cases. That's not just risk reduction. That's competitive advantage. Companies can move faster, knowing their IP rights are protected consistently. Warranties, the promises that determine who pays when things go wrong. Express warranties make specific promises. The software will perform according to documentation. The services will meet professional standards. The products will be free from defects. But I regularly see warranties that promise the moon without defining what the moon actually is. As implied warranties exist whether you mention them or not. The warranty of merchantability, fitness for particular purpose. Smart contracts explicitly address these. Smarter contracts disclaim them appropriately when needed. The smartest contracts balance warranty coverage with business reality. Template comparison engines powered by artificial intelligence match warranty language against approved standards instantly. They flag missing critical warranties that leave you exposed. They identify overly broad disclaimers that might be unenforceable. Here's what's powerful. The artificial intelligence assesses warranty coverage adequacy based on deal context. $1 million enterprise software deal needs different warranties than a $1,000 consulting engagement. The artificial intelligence understands this context and adjusts its analysis accordingly. One manufacturing company reduced warranty-related claims by 60% after implementing artificial intelligence-powered warranty review. They discovered their standard warranties were creating obligations they couldn't actually fulfill. The artificial intelligence helped them align promises with capabilities. Liability and indemnification, where lawyers earn their fees and companies protect their futures. Liability caps limit exposure, typically tied to contract value. 1x annual fees, 12 months of charges. But I've reviewed contracts with no caps at all. Unlimited liability for a $50,000 project. That's betting the company on every single deal. Carve-outs identify where caps don't apply. Intellectual property infringement, confidentiality breaches, gross negligence. Each carve-out is a hole in your protection. Too many holes and the protection becomes meaningless. Indemnification requires one party to cover the other's losses. But indemnification without liability caps is writing blank checks. I've seen companies indemnify against patent infringement without realizing they're potentially liable for hundreds of millions in damages. Risk analysis tools powered by artificial intelligence transform liability management. They flag missing liability caps immediately. Not buried in page 47, but highlighted in executive summaries. They identify overbroad indemnity obligations that could bankrupt your company. Artificial intelligence compares cap amounts against company standards and industry benchmarks. If your standard cap is 2x contract value, but this agreement has 10x, you know immediately. It highlights asymmetric risk allocation, where you're accepting more liability than your counterparty. One technology services firm reduced their financial exposure by 70% using artificial intelligence-powered risk analysis. They discovered they were accepting unlimited liability in 30% of their contracts. The artificial intelligence helped them implement consistent liability protection across all agreements. Their insurance premiums actually decreased the following year. Term and termination, your escape route when things go sideways. The initial term establishes contract duration. 1 year, 3 years, perpetual. But duration without exit rights is a prison sentence. I consulted for a company locked into a 5-year contract with a failing vendor. No termination for convenience, weak termination for cause provisions. They spent 2 years trying to escape. Renewal provisions hide expensive traps. Automatic renewal unless you notify 90 days in advance. But nobody tracks these dates manually anymore. I know companies paying for software they haven't used in years because auto-renewal kicked in. Termination rights provide flexibility for cause, for convenience, for insolvency. Each needs specific triggers and procedures. Too restrictive and you're trapped. Too loose and your revenue becomes unpredictable. Calendar integration with artificial intelligence transforms deadline management. The system extracts critical dates automatically. Renewal deadlines, notice periods, term expirations, everything flows into your calendar with appropriate advance warnings. The artificial intelligence sends renewal reminders 90 days in advance, not 90 minutes like humans tend to do. It flags unfavorable auto-renewal terms during negotiation, not after you're locked in. It identifies missing termination rights before you need them. One software company prevented unwanted renewals in 99% of cases after implementing artificial intelligence-powered term tracking. They saved over $3 million in the first year just by terminating unused services on time. Their procurement team calls it their best investment ever. Slide 15. Governing law and dispute resolution. Governing law and dispute resolution, deciding where and how you'll fight if things go wrong. Governing law determines which jurisdictions laws apply. New York for finance, Delaware for corporate matters. But I've seen contracts with governing law from jurisdictions where neither party operates. That's asking for expensive complications. Venue selection determines where lawsuits happen, your backyard or theirs. The difference could be millions in travel costs and local counsel fees. One client fought a case in Alaska for a contract performed entirely in Florida. The travel costs exceeded the dispute value. Arbitration provisions promise faster, a cheaper resolution. Sometimes they deliver, sometimes they create parallel proceedings that double costs. The devil's in the details, which arbitration rules, how many arbitrators, who pays. Policy enforcement engines ensure consistency across your contract portfolio. The artificial intelligence flags non-preferred jurisdictions instantly. If your policy requires a New York law, but this contract specifies California, you know immediately. The system ensures arbitration clauses match company standards. It identifies unfavorable venue selections that put you at a disadvantage. It suggests approved alternative language that's been pre-vetted by legal. One consulting firm reduced litigation costs by 50% through favorable form selection. Their artificial intelligence ensures every contract uses their preferred jurisdiction and dispute resolution process. They haven't had a venue fight in 3 years. Boilerplate. The paragraphs everyone ignores until they desperately need them. Assignment clauses determine if contracts survive acquisitions. I watched a startup lose their largest customer because the contract prohibited assignment without consent and they forgot to get consent before their acquisition closed. Entire agreement clauses prevent side deals and verbal promises from creating obligations. Amendment provisions specify how contracts change. Severability saves the contract if one provision fails. Force majeure, that's force majeure, meaning superior force, excuses performance during extraordinary events. Each provision serves a purpose. Missing even one can be catastrophic. Completeness checkers powered by artificial intelligence detect missing boilerplate instantly. They ensure standard language matches approved templates. They flag non-standard modifications that could create problems. The artificial intelligence verifies all required provisions are present, not just checking boxes, but understanding which provisions your specific contract needs. A software license needs different boilerplate than a services agreement. One law firm achieved 100% boilerplate compliance using artificial intelligence checking. They haven't had a contract invalidated for missing provisions in 4 years. Their malpractice insurance carrier actually reduced their premiums based on this track record. Signatures and exhibits. Where promises become legally binding obligations. Signature blocks seem simple until they're wrong. Wrong title, wrong entity, wrong authority. I saw a $10 million deal unravel because the signatory lacked corporate authority and nobody verified until after disputes arose. Exhibits and schedules contain the details that make contracts work. Specifications, statements of work, pricing tables. But I regularly see contracts that reference Exhibit A when no Exhibit A exists. That's not a typo. That's a hole in your agreement. Digital signature validation powered by artificial intelligence confirms signer authority against corporate records. The system knows who can sign for what amount, who needs board approval, who requires countersignatures. The artificial intelligence ensures all referenced exhibits are attached. It flags missing appendices before execution, not during litigation. It verifies execution completeness, all parties signed, all dates filled, all exhibits attached. One financial services firm reduced execution errors by 95% using artificial intelligence validation. They haven't had a signature challenge in 2 years. Their general counsel told me it's the best risk reduction investment they've made. So here's where we've arrived: the complete transformation of legal operations through artificial intelligence. The foundation is structured contracts. All 14 components consistently organized, predictably formatted. This isn't about rigid templates. It's about creating contracts that both humans and machines can understand efficiently. And the engine is artificial intelligence technology. Natural language processing extracts insights. Machine learning identifies patterns and risks. Large language models generate and refine content. Each technology amplifies human expertise rather than replacing it. The outcome transforms how legal teams operate. They shift from manual review to strategic advisory. They process 5 times more contracts with 80% fewer errors. Junior associates learn faster because they see consistent patterns. Senior partners focus on complex negotiations instead of routine review. London. 3 years ago, they were a traditional practice drowning in paper. Today, they are processing more volume with fewer lawyers while increasing both profitability and client satisfaction. Their secret: they designed their contracts for both human understanding and machine intelligence. The firms and companies succeeding today understand this fundamental truth. Contracts are data. Structured data that artificial intelligence can analyze, optimize, and manage at scale. The anatomy of a legal contract isn't just academic knowledge anymore. It's the blueprint for competitive advantage in modern legal practice. Whether you're a solo practitioner or managing a large legal department, the principles remain the same. Structure enables automation. Automation enables scale. Scale enables strategic focus. And strategic focus is where legal professionals create real value. Look, I've been in technology long enough to see dozens of revolutionary trends fizzle out. But artificial intelligence in legal contracting isn't one of them. This is real, it's here, and it's accelerating. The law firms and legal departments implementing these approaches aren't just keeping up. They're pulling ahead. They're winning more business, reducing risk more effectively, and actually enjoying their work more because they're focused on intellectually challenging problems instead of mundane review tasks. Remember, you don't need to transform everything overnight. Start with one contract type. Standardize its structure. Implement basic artificial intelligence extraction. Measure the improvements. Then expand. Every firm I've worked with that followed this approach succeeded. Everyone that tried to boil the ocean at once struggled. The legal profession is experiencing its most significant transformation since the invention of word processing. The attorneys and firms that embrace a structured contracts and artificial intelligence automation will thrive. Those that don't will find themselves competing against firms that can deliver faster, better, and cheaper services. If you're ready to start this transformation, begin by auditing your current contracts. Look for patterns in your 14 components. Identify where standardization would create the most immediate value. Then start building your structured templates with artificial intelligence processing in mind. The future of legal practice isn't about artificial intelligence replacing lawyers. It's about lawyers leveraging artificial intelligence to deliver extraordinary value that wasn't possible before. And that future is already here for those ready to embrace it